A federal judge recently ruled that the IRS was illegally charging penalties and interest to millions of American taxpayers during COVID. And there's a hard deadline, July 10th, 2026, to file a claim and get your money back. After that date, in most cases, the statute of limitations expires and the money is gone forever. And so I'm going to tell you exactly what happened, exactly how to know if you qualify, and exactly what to do before the window closes. Now, before you click off thinking this is another sketchy ERC ad, just stop. This is not a tax credit. This is not a loophole. This is not some gray area strategy where you're playing games with the IRS. This is a federal court, the U.S. Court of Federal Claims, telling the United States government that the IRS applied its own law incorrectly and that taxpayers who were penalized during COVID may be entitled to refunds. The case is called Kwong versus the United States, and this was decided in November of 2025, and it has been covered by some of the most respected names in tax law in the country. This is not fringe, this is a mainstream tax litigation with real implications for real business owners. And the reason most e-commerce entrepreneurs have never heard of it is because it lives in the tax corner of the internet, and nobody's broken it down in plain English. And so that's what we're going to do today. As a disclaimer, if you're not a client of ours at EcomBalance, then we don't know your unique situation. So be sure to speak with your CPA or your tax team to ensure that this video applies to you. Now, if you'd like to meet with our specialized team about your business tax situation, you can schedule a call with us at bit.ly/EcomBalance consult. The link is below and in the description for you. To understand this, you need to know about one specific law. Section 7508A of the Internal Revenue Code. This law has been on the books for years. Its purpose is simple. Whenever the president declares a federal disaster, the IRS is required to postpone tax deadlines for any affected taxpayers. Filing deadlines, payment deadlines, the clock on penalties and interest. Whenever FEMA declares a disaster, Section 7508A kicks in automatically. Now, COVID-19 was declared a federal disaster, and so the incident period officially began on January 20th of 2020. FEMA then formally ended the COVID-19 national emergency on May 11th, 2023. And so under the statute, the postponement extends 60 days beyond that, landing on July 10th of 2023. That means the law, as written, postponed certain tax deadlines from January 20th, 2020 through July 10th of 2023. Here's the problem. The IRS didn't honor the full window. During COVID, the IRS issued its own guidance in two different forms. First, Notice 2020-18, and second, Notice 2020-23, both of which extended certain deadlines to July 15th of 2020. Now, after that, the IRS largely reverted to normal filing and payment calendars, even though the federal disaster declaration was still active. So the IRS was essentially treating COVID like a short-term regional storm when the law said that it was a multi-year national disaster with multi-year relief attached to it. So when taxpayers missed deadlines in 2021, 2022, and even into 2023, the IRS hit them with failure to file penalties, failure to pay penalties, underpayment penalties, and interest. So a taxpayer named Kwong said, well, that's wrong. The statute says the disaster period runs through FEMA's official end date. You don't get to override that statute with a notice. And so they took it to federal court. And in November of 2025, the U.S. Court of Federal Claims agreed. The ruling in Kwong versus the United States is that the U.S. Court of Federal Claims said that the version of the Section 7508A automatic disaster postponement in effect for the COVID-19 pandemic suspended filing and payment deadlines for the entire declared disaster period from January 20th, 2020 through July 10th of 2023. Penalties and interest charged during that window were potentially invalid, and the affected taxpayers are entitled to refunds or abatements. So let that sit for a second. I want to speak directly to e-commerce business owners and really any entrepreneur here, because this cohort was hit harder than almost any other category of taxpayer during this exact window. Think about what actually happened in the e-commerce world from 2020 to 2023. In 2020, supply chains collapsed. Container costs went from $2,000 to $20,000 overnight. Shipping timelines ballooned from 3 weeks to 4 months. Cash flow became completely unpredictable. And sellers who had been profitable on paper were suddenly cash poor because their inventory was stuck in a port somewhere. So a lot of business owners made late tax payments, not because they were being irresponsible, but because the money genuinely wasn't liquid when it was due. In 2021, Apple dropped iOS 14.5 in April, wiping out Meta ad targeting for a huge portion of the industry. Revenue that sellers had been projecting based on 2020 performance completely disappeared. Estimated tax payments made in Q1 of 2021 were based on a business model that effectively stopped working in Q2, and so underpayment penalties followed. In 2022, there was an inventory overcorrection crisis. Sellers who had been stocking aggressively to fight those stockouts suddenly had warehouses full of product that they couldn't move, and Amazon storage fees were crushing margins. Cash was tied up in dead inventory, people filed late, and people paid late, and so penalties accrued from that. For every one of those situations, if you were charged a penalty or interest during the period from January 20th of 2020 through July 10th of 2023, the Kwong ruling says that those charges may have been invalid. There's also a structural consideration that's unique to e-commerce operators. A lot of you are not just running one entity. You have an LLC that holds the brand, an S Corp for payroll optimization, maybe a holding company, maybe a separate entity for a private label brand. That's multiple tax returns, multiple years, multiple potential penalty assessments, multiple potential refund claims. So let's say that you're a taxpayer who filed for their 2021 return on July 12th of 2022. You got hit with $10,000 in penalties and interests, paid it on August 8th of 2022. And under the Kwong analysis, that taxpayer can file a refund claim today and get the entire $10,000 back of those penalties and interests. One tax year, one entity, $10,000. Now, if you have 3 years of penalties across two different business entities, well, I'm sure you're doing the math right now. Ultimately, that's a lot of money that adds up. So let me give you a simple framework to know if you have a potential claim. Question 1, were you assessed any of the following charges for tax years of 2019 through 2022? Again, that's for the tax years of 2019 through 2022. First, a failure to file penalty. Second, a failure to pay penalty. Third, an underpayment of estimated tax penalty. Or fourth, interest on any balance due. Now, if yes, you have a potential claim. All 4 of those categories are covered. Question 2, did you pay those penalties and interest? If you paid, you file for a refund. If you still have an outstanding balance that you haven't paid, you actually file for an abatement, meaning that you request that the IRS eliminate that balance entirely for the penalties and interest. Critically, if the amount is unpaid, there is no statute of limitations on the abatement request, as long as the IRS's collection window hasn't closed. And question 3, are you inside the statute of limitations? So here's where it gets slightly technical, but I'll simplify it as best I can. Normally, you have either 3 years from when you filed your return or 2 years from when you paid, whichever is later, to file a refund claim. So for most people with 2021 and 2022 penalties, those windows would have already closed. But under the Kwong analysis, the COVID postponement period is excluded from the statute of limitations clock. That means the window extends through July 10th of 2026 for most COVID-era claims. Congress also passed a new law, Section 7508AF, added in December of 2025, which extends the 3-year look-back period for refundable amounts. Without this, you could technically file a timely claim but have no refundable amount because the payment date fell outside of that look-back window. The new law fixes that, but only for claims that are filed after December 26th of 2025. So here's the practical bottom line. File before July 10th, 2026. That's the line. Everything before it, you're likely covered. Everything after it, you're likely not. And here's the action plan. 5 steps. Do not skip any of them. So step 1, pull your IRS account transcripts today. Go to irs.gov, log into your IRS online account, or create one if you don't have it. Pull your account transcripts for tax years 2019, 2020, 2021, and 2022, and look for any line items showing penalty assessments or interest charges. Screenshot everything, write down the dates, the amounts, and the tax years, and do this for every entity that you own. This is the foundation. And if you work with a CPA, be sure to call them today to see how they can assist you. You might also be able to sign authorization forms, allowing them to pull the transcripts on your behalf. Now, in addition, they can help prepare any refund or abatement claims for you. Do not wait until June of 2026. Now, step 2, add up the numbers. So total the penalty and interest amounts across all years and all entities. This is your potential refund number. For some of you, it will be a few $100s. For others, it will be a significant amount. Now, step 3, file Form 843. Form 843 is the IRS's official form for claims for refund and requests for abatement. You'll file one for each tax year where you have a claim. Now, in the explanation section of the form, you must include 4 things. First, that this is a protective claim based on Kwong versus the United States, and I'll give the full documentation in the description down below. Second, why Section 7508A applies to your specific situation. Third, your refund amount calculation. And fourth, how your claim is timely under the refund statute of limitations. Now, step 4, you want to file it as a protective claim. The reason to label this explicitly as a protective claim is that the IRS is widely expected to appeal the Kwong ruling to the Federal Circuit Court of Appeals. As of today, no appeal has been filed. But the IRS almost always appeals rulings of this magnitude. A protective claim is specifically designed for situations like this, where your right to a refund depends on the outcome of pending litigation. The IRS will likely hold your claim until the courts give a final answer, but your claim will be on file, your statute of limitations will be protected, and if the Federal Circuit upholds Kwong, your money then gets protected. The IRS's own Internal Revenue Manual describes protective claims as preserving the right to pursue a refund based on the resolution of an issue contingent on future events. And that's exactly what this is. Now, step 5 is to work with a qualified tax professional. I'm going to be direct here. This is not a DIY project. The statutory analysis, the proper framing of Form 843, the multi-entity coordination, this requires expertise. And when you interview a tax professional, ask them specifically, are you actively filing Kwong protective claims for clients? And if they hesitate or don't know what you're talking about, find someone who does. Now, on fees, a reasonable structure for this type of claim is a flat upfront fee to prepare and file. Some different tax professionals may have different structures for this, but that's typically what it's going to be, is a flat upfront fee. Now, this is explicitly permitted under Circular 230, Section 10. I want to be direct about the risks because I don't want anyone making decisions based on incomplete information. Risk number 1 is the IRS may appeal and win. The Federal Circuit could overturn the lower court's ruling, and if that happens, your protective claim just gets denied. You don't get the money. That outcome is possible. Anyone telling you this is a guaranteed refund is either misinformed or selling you something. Now, risk 2 is the IRS processes these slowly. Even if Kwong is upheld on appeal, the IRS has discretion on how it processes protective claims. The IRM specifically states the IRS can delay action until the contingency is resolved. So you could be waiting years for a final answer. Risk 3, not everyone who paid penalties qualifies. Kwong analysis applies when Section 7508A's automatic postponement should have applied, but didn't. There are edge cases and specific fact patterns that need to be evaluated here. This is another reason you need a qualified tax professional reviewing your specific situation, not a generic form filler. Now, the cost-benefit calculation here, though, is pretty straightforward. Filing a protective claim costs a few $100s in professional fees and a few hours of your time. The potential upside is thousands or tens of thousands of dollars, depending on your scenario. The worst case scenario is your claim is denied and you're out of the filing fee. That's an asymmetric bet worth taking. Now, what you should not do, pay large upfront fees to anyone promising guaranteed results here. There is no guarantee here. The ruling is real, the opportunity is real, but the outcome is uncertain until the Federal Circuit weighs in. So here's the bottom line. A federal court ruled the IRS got it wrong. The COVID disaster relief law said that tax deadlines were postponed through July of 2023. The IRS ignored that and charged millions of taxpayers penalties and interest they legally should not have owed. You have approximately 70 days from the day I'm recording this to file a protective claim and get in the queue. So don't forget, if you'd like to meet with our specialized team about your business tax situation, you can actually schedule a call with us at bit.ly/EcomBalance consult. The link is below and in the description for you. And here are 3 things that you can do this week. 1, pull your IRS account transcripts for 2019 through 2022 and look for any penalty or interest line items. 2, call your CPA or tax attorney and ask them specifically about Kwong protective claims. 3, file Form 843 before July 10th of 2026. This is one of the rare moments where a court has said in plain legal terms, the government owes you money. Don't let the deadline pass without at least checking. If this video saved you money, share it with another business owner who is grinding through COVID and got hit with IRS penalties they didn't deserve. I'll see you in the next one.